Hello friends and welcome to one more informative video on Careers Talks. Today we are going to understand different types of work contracts in the Netherlands. If you like the information, please subscribe our channel and like the video. Thanks. Once you have got through the stressful phase of job interviews, and your new employer has made you an offer, then you need to check the details of the employment contract before you can get to work. First point, checking and signing your work contract. One of the first things that will happen after you accept a job in the Netherlands is that the company will present you with a labor contract, arbeidsovereenkomst, outlining all the aspects of your employment agreement. It is not necessary to sign the agreement immediately. Your new employer will usually allow you to take the unsigned contract home to look over it for a day or two to ensure you fully understand it. If there are any elements you are uncertain about or disagree with, then you should discuss them with the company before signing. If you are especially concerned or confused, then seek the advice of a lawyer or employment law specialist. Once you have signed the contract, you are officially in paid employment, loondienst. Let's check the Dutch labor contract checklist. It is important to carefully check all the conditions of your labor contract before signing. Here is a list of the most common contract elements. Role description, working hours, trial period, privileged overtime expectations, flexible working possibilities, holiday leave, salary, bonuses and 13th month salary, pension contributions, social security contributions, company car and or mobile phone, coverage of additional expenses, for example public transport, company privacy and confidentiality policies, conditions of contract termination, non-competition clause, concurrent year bedding. Let's discuss about types of employment contracts in the Netherlands. There is a variety of employment agreements for employees in the Netherlands, with temporary and permanent contracts being the most common. First type of contract is temporary labor contract, tijdelijk contract. A temporary contract is for a specific period of time, such as 6 months or 1 year, with a predetermined end date. A dismissal procedure is not required to terminate a temporary contract at the end of its duration. It is quite common for Dutch employers to offer a second temporary contract when the first expires, but it's not guaranteed. As of January 1st, 2020, a temporary contract automatically changes to a permanent contract if an employee has received more than 3 successive temporary contracts, or if an employee has had several temporary contracts with his employer for more than 3 years, unless there are other rules in the collective labor agreement. Second type of contract is permanent labor contract, vast contract. A permanent contract is for an indeterminate period of time with no end date. This type of contract can only be terminated if the employee resigns, for example found another job in the Netherlands or abroad, or if the employer finds reason to end the contract, which must comply with strict legal guidelines. Third type of contract is with a recruitment agency, contract. A contract with a recruitment agency, bureau, is a less common form of labor contract. You enter an agreement with a recruitment agency, whereby they are your legal employer and salary provider even though you will be working for a third party. It is important to note that in such contracts there is limited protection against dismissal. Fourth type of contract is zero-hour contract, nuluring contract. A zero-hour contract can exist as either a temporary or permanent work agreement. In a zero-hour contract, an employee has no fixed working hours. This allows for a flexible working arrangement where the employee can be spontaneously rostered on. Employees on zero-hour contracts have similar rights as employees with regular contracts, including sick leave and holiday pay. However, such contracts can leave employees vulnerable as a steady income is not guaranteed. Employees may also be obliged to accept the hours requested by the employer. As of January 1st, 2015, it is no longer allowed to extend zero-hour contracts indefinitely. Fifth type of contract is freelancer contract, the model of the overeenkomst. Freelancers are not officially in service, loondienst, with an employer. However, they are required to draw up and sign a specific type of contract with a client that defines their working relationship. This is to clarify who will be responsible for contributing to the freelancer's welfare or unemployment benefits. This new freelancer contract arrangement introduced in 2016, is called the model contract system. Freelancers and their clients must use or adapt a template contract provided by the Dutch tax office. Friends, if you like information given in this video, please subscribe, like, click on bell icon for more interesting videos related with career in Netherlands.